Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So hello audience. We're back for another episode of International Arbitration Across the Pond. This is Charles Harris, and I'm here with my co-host, Kwadwo Sarkodie. You want to say hello?
Yeah, very good to see you again, Chucky. And very looking forward to meeting our guests.
Okay, so continuing with our theme from past podcasts, we have the distinct pleasure today to speak with two senior leaders from one of the premier arbitration and mediation services, and that's JAMS. And for those who don't know, JAMS is an acronym for Judicial Arbitration and Mediation Services. And I didn't know that until recently. But let me quickly introduce our guest, who will learn more about in a few minutes. First, we're happy to have Kim Taylor, the Chief Legal and Operating Officer at JAMS. So that's CLOO is the acronym, right? And yes. We also have Ranse Howell, the Director of International Operations at JAMS. So hello to you both, and thank you for being here with us today.
Hello, nice to be here.
Hello, and thank you.
So I was just thinking about what we would call this episode, and I think a good title for it, based on what we plan to talk about, is Everything JAMS. And the reason I think we'll call it that is because we're going to discuss a number of different topics, including how the organization is responding to COVID-19, your international presence, diversity, just to name a few of the topics. But I'm excited about it, and I think it's going to be an interesting discussion, not only for Kwadwo and I, but also for our audience. So let me first turn to you, Kim, and ask you to tell us a little more about yourself.
So I'm as Charles said, the Chief Legal and Operating Officer of JAMS. I've been with the organization for about 21 years. So I've had the pleasure of seeing it through a really strong period of growth, both domestically in the U.S. and abroad. And so I enjoy working with Ranse and have been shepherding our international growth efforts now for a little more than a decade. And I'm happy to be here to talk about JAMS. I'm very proud of the organization and my role in it.
Thank you. So she said your name a little bit different. Ranse?
Well, you could say Ranse, you could say Ranse, you could say anything that starts with an R, because that's, that's...
No preference?
No, either way is fine.
Okay. Well, why don't you tell us a little bit about yourself? Thank you.
Yeah, my name is Ranse Howell. I'm the Director of International Operations, and I've been with the organization for the past 3 years. And I spend a good portion of my time between London and also our major international offices in America. And I lead a fantastic team under the stewardship of Kim and our senior leaders, who basically look for opportunities to enhance, excite, educate clients and other users, and also potentially educating them that the JAMS isn't necessarily what people think it is, and it is much more. And I'm so glad that we're here to have that conversation today.
Okay, thank you. So one of the things, of course, we're an international arbitration focused podcast. You mentioned a little bit, Ranse, when you were just talking about your responsibilities, kind of a setup in the States as well as internationally. Mm-hmm. I think I want to turn to you, Kim, and kind of tell us a little bit about the structure of JAMS, how your operations are set up, and that type of thing.
So currently we have 28 offices in North America, and our international headquarters are in London. We have been around for more than 40 years and really started out primarily as or more focused as a mediation organization, first on the West Coast of the United States and then gradually moving east. The last, as I said, 20 years have been a time of quite a bit of growth for the organization. And over the years, as we've grown and as our arbitration practice has grown, we started doing a lot of business with multinational corporations and global law firms. and realized that we wanted to make sure that we were positioning ourselves in a way that those organizations around the globe understood that we could bring the same high level of client service, case management expertise, and neutral expertise to disputes that happen anywhere in the world and involving parties all over the world. In concert with our commercial activities, we also have a foundation, and within that foundation, we operate a international fellowship program. So for the last decade or so, we've been inviting in about a dozen or so fellows from around the world who want to learn about mediation and about the business of mediation. And we bring them into the U.S. for some intense training, and then they have opportunities to shadow some of our neutrals in their mediation and arbitration proceedings, and then take that knowledge back to their home countries. So that's enabled us to build a very strong network of people around the world that are part of the JAMS family.
All right, so just a little bit follow-up question about the fellowship program. Are there any for our listeners, or who are you looking for that program? Tell us a little bit about kind of how you decide, because it sounds like a great opportunity.
It is, and I would encourage anybody who's interested to go onto our website, and you can find information about it's called the JAMS Weinstein International Fellowship Program. It was originally sort of supported and endowed by one of our premier founding neutrals, Dan Weinstein, who is a very prominent judge, former judge in California. And we look for people who are, actively engaged in dispute resolution, conflict resolution in their region, and have a desire to. Sometimes they are desiring to develop mediation in their country or region. Other times they're looking for ways to bring dispute resolution processes and conflict resolution processes to their court systems. And so we get hundreds of applications every year, and it's always very challenging to pick the qualifying applicant. Anytime I encounter somebody who's interested and passionate about developing mediation around the world, to look into the program and consider applying for it.
Thank you for that. Kwadwo?
Right, so I'd like to move on to another subject, and this is something that Chucky and I have touched on many times in the course of our podcasts. It's a subject we can't really ignore, and that's the impact of COVID-19 in relation to international arbitration. So taking a step back, perhaps to start with, and maybe looking back to what I'll term the old normal pre-COVID, we note that prior to March 2020, international commercial arbitration was one of JAMS' fastest growing practices. Now, why was that?
So I think, first of all, it's one of these sort of things. If you were speaking to us this time in March, the sort of conversation we'd be having and the focus we'd be having would be quite different. And I think what we saw was, because we were trying to internationalize the business, we saw a terrific opportunity for developing and enhancing international arbitration. But part of that was, first of all, identifying to new users and those who are current clients of ours, who are we? What are we? Because many people thought we were just a mediation organization that provided domestic services primarily in Southern California. And where are we located? Are we only just in the US, or do we service arbitration clients outside of the US? And the most important thing is, why JAMS? Why us? Why our neutrals? Why our panelists? And we have a terrific group of individuals who have a broad range of experience, and it's really about reaching out to clients, to organizations beyond the US, and also those clients in the US who have cross-border business, to see how and why they should use JAMS. And we have introduced a number of different initiatives in order to try and promote that, such as, and we'll talk about this a bit later, international arbitration centers, and also equipping our resolution centers for the disputes of the future.
Thank you very much indeed, Ranse. That's been really helpful, and look forward to touching on some of those subjects a bit more later in the podcast. But how has COVID-19 impacted all of that?
I'll jump in there because it had a tremendous impact. Actually, Ranse was sort of, I think because of his travels around the world, was one of the first to sort of raise the alarm, if you will, with me, and that was in January. That, based on what he was hearing and what the news reports were saying, that this was likely going to develop into something pretty significant and would have potential impact on not just our business, but businesses around the world. We couldn't have envisioned that in March in the United States that the entire country would essentially be ordered to shelter in place or stay at home, depending on the terminology used. We had seen that happening in other parts of the world, but it came as something of a shock. We had long been planning to give our employees more flexibility to work from home, so we had been putting in systems in place in order to support that. But in February, we saw the need was going to be more imminent, so we began acquiring laptop computers and other electronic devices to enable that, and started to deploy those around the organization. But by mid-March, we were fairly confident that we were going to have to close all of our centers, and we did that at that time, and really worried about what that would do to our business, because most of our hearings are conducted in one of our centers around the United States or elsewhere in person. But what we found is that people were very quick to adapt to technology using platforms like Zoom or WebEx or other Microsoft Teams, BlueJeans. There's a number of platforms out there. Zoom has been the most popular. There had been some concerns, I think, initially about the security of that platform, but Zoom addressed that, and I think people are feeling very comfortable with it. So in March, our business, pretty much stopped for a couple of weeks, but by April, people were starting to, adapt to the virtual technology. We began offering, substantial and frequent trainings to both our arbitrators and mediators and to our external clients. And as the situation appeared to be going to drag on for more than just a few weeks, which we were, I think, hopeful for at the beginning, people started to get more and more interested in using the virtual platforms. And by June, we were doing as much business virtually and in some combination with some in-person hearings where some of the offices had reopened, but we were doing about the same amount of business that we had been doing the year before. And wow. throughout the summer, the fall, and into November, same experience. And people are continuing to set cases and appear to be just really adapting to this environment and this new normal. And I'm not sure we'll ever go back to exactly the way it was before.
Okay, thank you very much, Kim. That's really interesting to hear. And Ranse, in this regard, has COVID-19 presented any opportunities for JAMS, have you found?
Well, I would say, given all what Kim's just said, it certainly has, because in many ways we've made the impossible possible in a very short period of time. And what's fascinating is we've been saying to clients, to practitioners, to organizations that having hearings using a variety of different platforms is certainly something that's possible and should be tried. But there was a huge amount of resistance. People wanted to operate arbitrations in the traditional way, and when we moved on to the virtual hearing platform, there was initially again a concern about it, but actually there's been a recognition it does a number of things. It provides flexibility. Clients are able to schedule a lot more creatively. There's a broader pool of neutrals that are available. And also, you could use a hybrid process, which is partly in person, partly and virtual. This is the sort of thing that people are considering that this will be the way forward. And in having conversations with other institutions, they've also seen the same thing. But I don't necessarily say that it will go back to how it used to be. I think we can be a lot more mindful about how we use the time, how we use our facilities, and we could have almost, and what we're considering is a network of hearing facilities. So therefore, people could be placed in different parts of the country and the world without necessarily feeling concerned about having to travel and about having it at a time that's flexible for them. So I think that whilst it was initially a challenge, we made it possible, and also we're learning from practice and we're continuing to grow.
Oh, that's great to hear. So we might well come out of this more efficient and more flexible. That's great news.
One would hope.
Chucky?
Sure. So picking up kind of on this point, one of the things that we see a lot of arbitration institutions doing now is revising their rules to make sure that remote hearings are permitted and the parties are able, of course, the parties can agree to anything, but the arbitrators can demand remote hearings. And I know that we'll talk about this a little in a couple of minutes, but I know that your rules are pretty recent, I think 2016, and we're talking about your arbitration rules. But are there any plans to bring your rules up to expressly permit virtual hearings? And I know that video conferences are permitted for preliminary hearings, but not necessarily for final evidentiary hearings.
Yes, our domestic rules do permit it for evidentiary hearings, and but we're updating all of our sets of rules, including our international rules, in Q1 of next year. And we're going to specifically provide that the arbitrator has full authority to determine that the hearing or any portion thereof can be conducted in person or virtually by conference call, video conference, or other communications technology with participants in one or more geographical places or in a combined form. And so that'll be rolled out probably by the end of Q1.
Yeah. All right. Well, that's good to hear. We'll get into the rules a little bit more later. One of the things I did want to discuss that Ranse, I think you have highlighted is the idea about some issues with virtual hearing and the access and the virtual hearing not everybody not having access to it and potential issues surrounding that. Can you comment on that?
Sure. So there's a couple of things that we've been hearing from clients. That first of all, there is a concern about if you don't have it, if you're not all in the same space, and you're in a variety of different locations, who else potentially could be in the room with them? What is the security as far as the cybersecurity protection, and also the ability to really connect and understand through body language and other sort of forms of communication. Now, we have in our development or international arbitration centers developed a sort of process where we can potentially place cameras and also place individuals where they can be seen. So therefore, you can see people like the conversation we're having. We are engaging, we're understanding what we're doing, and so that actually helped. But what we're also considering is if you have, say, an arbitrator in, say, an office in Los Angeles and an arbitrator in an office in New York, and say we have some clients in Washington, then coming to our facilities, you have the same care, you have the same comfort and knowledge that who's in the room is actually who should be in the room. And also, we will provide assistance that it's streamlined and will assist the process going forward. And I was at a recent Hong Kong International Arbitration Center event, or was a webinar, and they were talking about the hearing where you have 14 to 15 different individuals in a variety of different places. Clients have also said that they've been using international arbitration centers not for everyone to come together, but almost as a hub, and then that they connect with different offices and different practitioners globally. So I think as we go forward, we can be thinking about what is required, what are some of the concerns, and answer and anticipate some of those concerns. So therefore, we can promote and develop practice going forward.
I'd like to also add that although we are going to expand our international rules to permit arbitrators to order in-person hearings or order people to participate virtually or hybrid thereof, we're also being careful to make sure our arbitrators are ensuring that all of the participants have equal access to technology and that no one's disadvantaged by not having sufficient bandwidth or not having maybe the technical equipment that they need to participate fully. So while we are excited about the opportunities that technology provides, we're also mindful that it's not necessarily uniformly available and that our arbitrators need to be mindful of that in terms of ensuring due process.
And if I can add also to what Kim has just said, one of the concerns about having virtual hearings for particularly for parties who are outside of the US and potentially in say Latin America or Africa is the same consideration and concern. So it's about partly it's access to regular internet service and regular, even sometimes even regular electricity. So there's a question about, if we are moving into this way forward, what access do we need to provide, and are we making sure that we're giving the opportunities and the flexibility that's appropriate?
Mhm. Those are very important points, and points that I've had to think about in my job as an arbitrator. So, I think that's something that we're going to have to look at on a case by case basis. Arbitration by arbitration, to make sure that everybody has a proper access. But I think it's a very important point to consider. But I guess the final question on remote hearings that I'll ask, and this isn't to either Ranse or Kim, but to you both, is, do you think, and I think I know the answer to this, that remote hearings are here to stay?
Absolutely. I think especially in arbitration for preliminary conferences, for motion hearings, for maybe arguments on discrete legal issues, I think for sure people are going to be reluctant to send large teams of people to remote locations and incurring travel costs and hotel costs and meal costs and just the disruption into normal work life. So I think people are going to look for ways to continue to embrace and leverage this technology. I also think that people, by the time hopefully the vaccines are working and we get past this, that I think there's going to be a strong desire for people to get together in person. I know we've scheduled some in-person meetings in our organization that we've now postponed or put off, and are doing holiday get-togethers over Zoom. But I think people are really anxious to get together, and for very high stakes cases, I also predict that lawyers and the parties are going to want to have the benefit of being able to advocate in person. So I think it's here to stay, but we'll also, we're not going to remain in this entire virtual environment forever either.
And it's one of the things that we reflect on, that traditional international arbitration in-person hearings was very much about habit, and this is what people were used to. And now we've had the opportunity to feel what it's like to be all virtual. People can then understand the flexibility and the need for in-person, and also for when they need to consider using the flexibility and the opportunity that the virtual world provides. So they can be strategic.
Good point. Kwadwo?
Thanks. No, it's really interesting to hear both of those last comments. Kim, I certainly share your view that there is a pent-up, I think, need for people to get back face to face, which we all miss at the moment under the current conditions. And I think once things do return to normal, that's going to be extremely important. And Ranse, it's great to hear what you described about being able to use both, be able to use the best aspects of both, be able to conduct hearings in person, to be able to use your centres and facilities, but also to be able to make the best of the technology, which has been shown through the lockdown period to be incredibly effective, and actually to enhance the ability to resolve disputes and to conduct processes in many cases. So really interested to hear that. I would like to move on now to look at expedited processes. We've seen that from a number of arbitration institutions, and I would really like to hear, perhaps from you, Kim, initially, what JAMS offers by way of expedited rules and expedited procedures.
So for our domestic rules, we have an optional expedited process built in, and the parties can opt into that, which provides for more truncated timelines and for very efficient disclosures and discovery processes. And we also embolden our arbitrators to exercise discretion and their arbitral powers to ensure that arbitrations sort of meet the goal of being more efficient and less expensive than court proceedings. So we also have efficiency guidelines in place that we encourage our arbitrators to adhere to, and they encourage that an arbitrator uses his sound judgment as informed by an international perspective, because we recognize that there's a perception sometimes that some of our arbitrators are retired judges from the U.S. court system, and there's sometimes an expressed concern that that they will sort of import U.S. style kind of discovery processes into an international proceeding. But we train our arbitrators at the outset and continually about the differences in expectations abroad. And so we want them to use their judgment. And of course, it's the parties control the process to a certain degree as well, but that the arbitrator keep that in mind. And that they pay very close attention to the pre-hearing process as a way to keep the process organized and moving along efficiently. That we encourage the use of written witness statements, which is much more of an international sort of expectation than a U.S. expectation. So we've built that in. And that they be careful about the use of dispositive motions. Again, sort of a U.S. import, these motions for summary judgment or other types of motions that can be very time consuming and costly, that those be used judiciously.
So you actually moved into the topic that we were going to talk about next, but I want to step back a little bit and talk about the JAMS efficiency guidelines. And you I think already answered this, but the impetus for that was this whole pejorative that Kwadwo and his colleagues like to use, which is U.S. style litigation or U.S. style discovery, and a concern about kind of the overarching and the broad discovery that you see in some U.S. courts.
Yes, and we've been aware of that for a long time. It's been an interesting debate on the U.S. side because we believe arbitration is a very effective way of ensuring a more efficient, cost-effective process and more timely, and allow parties to get past the dispute and on to their regular business, sooner than later, and not be tied up in court for years and years. But unfortunately, what happens often is that the parties themselves are so used to sort of the way they litigate traditionally. And there's this term that is used sometimes in the US called the litigization of arbitration. And so it ends up then being very much like a court process and then not fulfilling the aims of arbitration. And so we train our arbitrators to be to really manage the process. And so even every judge that comes off the bench, every attorney that leaves their practice and decides to arbitrate full-time with JAMS, they go through a pretty rigorous training program. And that is a big part of what we try to instill in them, and especially in international proceedings where the expectation is just very different. So we're aware of that. But the arbitrators sometimes complain that they're trying to manage the parties' expectations. So they want to give the parties, both sides, both counsel, the process that they want, but at the same time, they have to kind of keep things contained so that it doesn't get, out of control and end up being dissatisfactory to everyone.
So thank you for that. Let me ask you a few questions about something you mentioned, which is this positive motions. So that is a kind of U.S. litigation procedure method for an early disposition of a case. But as you've probably seen, a lot of international arbitrable institutions are now, the LCIA, the ICDR is thinking about it, but they're now thinking about putting an early disposition rule into their rules. So even though I was in a forum talking about this with the whole bunch of international arbitration types a couple of weeks ago, and one of the things somebody said is, look, just because it came from the U.S. doesn't mean that it's bad. And I see that, so I'm seeing that a lot of people internationally are starting to put these rules in. Like I said, is that something that you're also considering for your international rules?
Yes, we allow that. What we try to caution, because the dispositive motions can improve the efficiency of an arbitration. You can cut more quickly to whether the case has merit and avoid, a drawn-out process that might not need to occur. But broader motions that sometimes have very lengthy submissions and can require a lot of time and lengthy hearings to resolve in and of themselves can sometimes slow down the process. So we have a process where our arbitrators can sort of pre-screen the dispositive motion to determine whether they will have the discretion whether or not to allow it. And all with the aim of ensuring that this is something that will actually improve the efficiency and not drag the case on.
Thank you.
So I agree that there's lots of good things that can come out of the U.S.
Kwadwo?
Thank you very much, and yes, good to be hearing the US perspective, but also getting the impression of how international JAMS is becoming as well, and to hear how you're introducing and adopting features and aspects from the wider international arbitration space, but as Chucky points out, don't lose the good stuff from America as well. So.
And if I can add one thing more about the what we see as the potential need for efficiency and an expedited offering. One of the things that we're going to have to recognize is that businesses are almost in a kind of a shock at the moment. Really, what is the normal going to be like, and is there a normal? And so there is going to be a need for speed, and there's also going to be a need for a variety of different options, and also a variety of different mechanisms. And if you look at how construction has embraced a variety of different dispute resolution mechanisms in order to make sure the project stays on time, whilst also dealing with the conflict and getting a decision basically in time. And I think that the need for an expedited or an efficient decision is something that will be developing, and will potentially be something that we might need to educate people, the clients more about, because they may think that arbitration is as always and as it's always been. And so we need to sort of have a conversation and say, here are a range of different opportunities, and here are a range of different solutions for your current need and your imagined future need.
Thank you. So switching up to another topic now, and trying to draw some of these themes together and perhaps place them in a more practical context. Can you tell us a little bit about how you actually kick off an international arbitration with JAMS? How's this perhaps been changed or impacted by virtual working? And can we talk a little bit about the some of the templates and guidance that we've seen and reviewed from your website, which look very helpful and practical with regard to the request for arbitration?
So we have on our website the request for arbitration and the instructions for filing it, which is in conformance with our existing rules. We are going to be making some changes to those rules in our Q1 update next year to make it even easier to file. Right now, following sort of general old, to Rance's point, sort of old practices, currently the parties are required to file. They can file electronically, but they must also follow that up with a hard copy submission. And so that's going to be changed so that it will enable more efficient online filing and to get the case started. So I know we're going to talk at some point about sort of the digitalization that kind of accompanies this whole virtual world. And I'll just maybe say here that we had, for a few years prior to COVID, been developing an online case management platform. And so we're looking forward to being able to, and that was launched in August, and we're looking forward to being able to pair that up with our online filing and just make that just a very sort of a one-stop process for people who want to file a request for arbitration.
Oh, great. So we'll be looking at full electronic filing then, and then that seamlessly linking into electronic case management.
Correct.
Oh,
so we were developing all of this before, and it just, fortunately that it was all in the works, and it's been a great help to us in the last few months.
So yes, it's very much come at the right time, and all ties into some of the efficiency considerations, Ranse, that you were discussing earlier on.
Yes. And one of the other things that we also recognize is that often the international arbitration is triggered by clauses in the contract. Now, we spend a lot of time talking about what is the appropriate language for international arbitration, and really how should it be structured. And we have on our website a workbook that actually takes people through the various different elements in a clause, because what we've sometimes found is that individuals anticipate and believe that they have written down and that everybody understands and assumes that there is a common recognition of how they should be interpreted. We hear from our arbitrators, they spend a lot of time just trying to understand what is this clause trying to say. So I think if people go to our website and look at our clause workbook, we can actually say, here is the standard clause. And there are some other things you might want to consider, which is whether there's liability and and also consider about diversity, which we'll be talking about. So there's a whole series of different elements other than just the number of arbitrators, the seat, the language, and the standard elements that you want to include in the clause. And so it's about recognizing there is an opportunity to educate and inform.
Excellent. Thank you very much, Ranse. So final quick points, the two of you. Are there any other nuances or quirks or features about starting an arbitration with JAMS that you think set you apart from the other institutions?
I think that we've tried to make it as easy as possible to file an arbitration with us, and we've even sort of set our pricing structure in that way so that we have a fairly low upfront filing fee in order to get a case started. It's not based upon the amount in controversy, rather it's just a set fee. So that we hope that makes it just a little bit easier to get a case started. And we have specialists within our case management teams to commence international cases. So they have been specially trained to understand sort of the cultural differences and just the different expectations of the international community. So any case that comes in is given additional review by members of our general counsel's office and by our specialist case managers. And we hope that in that way, we can provide the best service.
So thank you very much. That wraps up part one of this episode, but please join us again soon for part two.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo, Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcasts. Thank you for listening.